you so much for being here. My name is Justin Terrell. I'm the Executive Director of the Minnesota Justice Research Center. And we are a small nonprofit just based out of Sabathani, just right up the block from George Floyd Square. And our mission is to transform the criminal legal system. We believe that everything from the beginning to the end and everything in between needs to be changed. That is, it needs to grow to become something completely different that is actually more effective and humane at delivering justice, and that people can actually put their trust in it. Does that sound like a good idea? Are you here because you believe in, okay. Are you sure? Are you sure? I want to say thank you to the Minneapolis Foundation for funding this report that we're releasing tonight. Dear Lord, I want to say thank you to our staff, especially one, Dr. Katie Remington Cunningham, who, if you find a typo in that report, you bet not say nothing to either her or Letta, who helped put this thing together, along with several other folks, Victoria, Josh. The acknowledgments in the report are there for you to see, but there's so many people that have contributed to this project, and especially thank you to the folks who actually shared their stories with us. You're going to hear from one of them tonight, and I want to say thank you to Marci and Anna for all the support that they've given. You'll hear from them tonight as well. And last little bit of thank yous and shout outs. We got like a couple of my board members in the building, so I just want to shout them out. Ahmad, Bridget, you guys want to just wave? Thank you. As you can imagine, it's a lot of work to keep me out of trouble as an executive director. It's not something a kid from this neighborhood, you know, most people didn't expect me to do that. And so in this role, it's important to have folks that hold me accountable. And so thank you to all the families who are here that support this work. I'm missing my son's football game tonight. There are plenty of parents in this room who have missed lots of things to fight for and advocate for justice. And I think all of you deserve a round of applause. So, Kara, am I forgetting anything? I thanked Katie. I did let her know that. So we also have Kara, our Associate Director, Kayla, Emily Baxter, and a wide range of folks who support this work who is in the room. Luke is here, who's married to Katie, so if she's acting crazy, it's his fault. But better, enough with the jokes and stuff. Seriously, thank you for being here. Thank you for supporting this work. This is not a moment, it's a movement. And in order to build a movement, we have to have the research and education and policy development work that equips people with the tools they need to fight for justice. And that's what this is really all about. So with that being said, just looking at my team, did I cover it? Who you pointing at? Okay, yeah. So with that being said, I just want to set up what we're talking about tonight real quick, and I'll pass it to Anna. So a big piece of our work is that we believe it's time to reimagine justice, creating space to actually reimagine how we deliver justice in the community. And so tonight we're going to focus on the pretrial process. So in the past we've talked about policing, which is sort of close to the beginning of the front of the continuum. Now we're moving to the pretrial process and looking at how it impacts people in Hennepin County specifically. I'm excited for you to read this report. It's a really good report. The first time I read it, I was like, I had to pick up my phone and call like 3 people and say, y'all need to see what I just read. And so I'm excited for you to read it, share it with the community, and make sure you get it out there. And with that, I'm gonna introduce Anna, who is going to talk about the pretrial justice process in general and why we need to transform it. Everyone, welcome Anna Hall from the Legal Rights Center.
Thank you, Justin, and thank you to the MNJRC team. It's really great to be here to talk to you a little bit about the pretrial process. As Justin said, my name is Anna Hall. I'm a criminal defense attorney at the Legal Rights Center in Minneapolis. And my work for the past 2 years has been bail reform and pretrial justice. So studying it, learning about the nuts and bolts of the pretrial process in the legal field, and also starting to imagine ways that we can change it. So really excited for MNJRC's work in this, and the work will continue after this report comes out. MNJRC is moving statewide to do reporting and research on this. So stay tuned, stay connected, because I think what we're going to come up with is going to be really exciting. All right, so this is just a little overview of what I'm going to talk about today, basics of bail. My job here is to contextualize what you're going to read, right? So the pretrial detention process is something that maybe you've heard the term cash bail, maybe you have a loved one who's gone through the criminal process, but even if you are intimately connected to the criminal legal world, the pretrial detention area is really confusing, it's convoluted, there's a lot going on there. It doesn't feel quite as intuitive as policing may. So my job here is to give you a little bit of background on the law so that you can understand what you're reading and react to it with sort of a basis of knowledge. So I'm going to go through a couple things about Minnesota specifically. I'm going to talk to you about the difference between bail and bond, because those are two terms that get thrown around a lot and are different. Talk to you a little bit about the harms of pretrial detention. So whether it's because of cash bail or something else, pretrial detention does harm families, individuals, communities. And then I'll talk to you about the purposes of bail, just to explain, is it working, is it not working? So Minnesota's Constitution has a right to bail. And what that means is that all people are bailable before trial, meaning that they are releasable before trial. So you often hear people say, wow, why did that judge let that person out on bail? In Minnesota, there is not a choice. Judges don't have the option to deny bail here. They must set a bail. What that means practically, because bail is just a condition of release, every person in Minnesota who is charged with a crime is releasable prior to trial as long as they meet certain conditions. One of those conditions is often cash bail, but there are other conditions as well. But I think it's really important to start with this basic constitutional right that we have in this state that doesn't exist in every state, and it doesn't exist at the federal level. Oh, and if you have questions as I'm speaking, please feel free to raise your hand as I'm talking, so that we don't lose the question in the slides. Just a little bit of data about the pretrial population in Minnesota. Our jails hold between 6,500 and 7,000 people on any given day in the state. And about 60% of those people, so somewhere around 4,000 people, are being held pretrial. So those are people who are legally innocent, they haven't yet had their day in court, they haven't yet been convicted, but they are in jail. And oftentimes that's because they can't afford to pay their bail. This is I'm exaggerating a little bit, but this is almost the extent of the data that we have about the pretrial system in Minnesota. The data just doesn't exist. It's not being collected. It's not being organized. It's not being made available to communities to look at and investigate. And so I wish I could give you more about what the overall state of pretrial detention looks like in Minnesota, but I can't. The report that MNJRC is giving out tonight is focused on Hennepin County, and it does dive a little bit deeper. And what we're hoping to do over the next 18 months in the larger statewide investigation is to really nail down this data and get a little bit more information out into the community. So the difference between bail and bond. Bail, at its most basic level, is the amount of money that a person needs to pay in order to be released before their trial. Or you could say before resolution of their case. Only less than 90% of cases go to trial, ever. So the term pretrial can be a little bit misleading, but we use it shorthand. So bail is the amount of money someone must pay to be released before trial or resolution of their case. Bond is completely different in this state. Bond is a legal promise to the court to pay the bail amount if the defendant doesn't ultimately come back. So the major difference here is when somebody posts bail, they're paying the full amount of money to the court that the court has assigned. When a company posts bond, what they're doing is just filing a piece of paper with the court saying, we promise that we will pay you this money if we don't get the defendant back. Yeah?
Yeah, I think it's also important to point out that the problem with bond versus bail is, let's say the judge sets your bail for $100, you pay the $100, you get up. Once your case resolves and you show up for court, you get the $100 back.
Yeah.
If you have a private company set your bail, let's say the judge sets your bail at $10,000, the private company says, hey, you have to give us $1,000, you never get that money back.
Yep.
So the private bonds are very expensive for the buyer, and you never get the money back, even if you show up for every court date.
Absolutely, that's a great point, and I don't want to steal Josh's thunder because he's going to talk after me and he's going to hit pretty hard on bail bond companies, but you're absolutely right, that's a major difference. And so typically bonds are not available to your average defendant, they're available to companies. Bail is what's available to our community members, which means there's a disparity there between what different people have access to. So I want to talk a little bit about the harms of pretrial detention. I'm going to hit on a bunch in a really short amount of time, recognizing that this is like a highly traumatic process. It's a highly traumatic experience. And so even though I don't have a ton of time to dive deep on it, I did want to acknowledge that this is difficult to think about and talk about. And what I'm about to talk about, you're going to see reflected throughout these posters in the quotes that are in the report. So first I want to talk about the legal harms. People who are held in pretrial detention are more likely to have all of these things happen. They're more likely to plead guilty. They are more likely to be convicted. They are more likely to get time in jail or prison as opposed to electronic home monitoring or some other community-based sentence. They receive longer sentences, and they are more likely to be arrested in the future. All of these legal harms are as compared to other defendants who are similar. Right, so we're not saying somebody who is detained pre-trial, you might say, oh, well, they committed a worse crime. They did something worse. When people are studying these things, when they're looking at, whether someone is pleading guilty or not, they're looking at similarly situated defendants and seeing basically apples to apples. If it's the same person with exactly the same situation and one is detained and one is not, the detained person will have these things happen to them more often. And I put a star by be rearrested in the future because I think it speaks to one of the major issues with the conversation around cash bail and pretrial detention, which is that it keeps the community safe. That's the line, right? It ensures that those people aren't going to go out and reoffend or cause further harm in the future. But when you spend time in jail or prison, there is a criminogenic effect. That's what we call it. Basically, it puts you in a position that is worse moving forward. Some things will happen to you that I'm going to cover in the next slide. Lots of things go on that make it more likely for somebody to be criminalized or be in a position where they are potentially causing harm. So pretrial detention has a lot of issues, but one is that it actually makes people more likely to commit harm in the future. So there's also some financial harms. People held in pretrial detention risk losing their jobs, if not their jobs, at least some income while they're being held. They risk losing their housing. You miss a rent payment, that's how it works. And they risk losing government benefits. I will say one exciting thing I found out about this week is this spring some U.S. senators introduced an act to remove this barrier. So it's written into law right now for like Medicaid and other federal benefits that when you're in pretrial detention, you can lose them. Some federal senators are trying to change that so that there isn't that immediate loss of benefits upon incarceration. But right now, that's definitely a risk for people. And then I don't ever really know what to call these. I sort of change it. I'm going to call them identity harms tonight. Things that affect sense of self, ability to move through the world in a way that is safe and generative for you and your community. Loss of liberty has all of these effects. It is humiliating. It fractures relationships. It fractures relationships with the community, with families. Our jails, making a phone call is really expensive, whether it's for the person making the call or the person receiving the call. It's deeply expensive. It's really hard to visit people in jail. Mental and physical health becomes a huge issue. Just this year alone, we've seen 11 people die in jails across Minnesota. That's devastating, and it didn't need to happen. It's not because jails need better health care, it's because people don't need to be in the jails. And then dignity. There's a huge loss of dignity when you're kept in a cage. And that's true of anyone kept in a cage, but it's particularly egregious for a person who hasn't yet been convicted, proven guilty, or pled guilty to a crime. Yeah.
Sorry for being a pain in the neck and everything.
No.
About the mental and physical health, I don't want to skate over that because serious, you know, antipsychotic meds and withdrawal meds. So it's,
Yeah.
I just want to underscore that.
Yeah, that's absolutely true. And, you know, I have clients who come to me all the time after they've been released and say, I was there for 5 days, I was there for 10 days, nobody ever gave me my meds for my schizophrenia, my bipolar disorder. I mean, these are things that are deeply disruptive to go off for even 1 day, much less 5 or 10. And again, I think that speaks to the potential to reoffend in the future is obviously linked to mental health. So if we're not taking care of people's mental health when they're incarcerated, then they're not going to come out a healthy member of our communities. So does bail work, right? Like we go through all these harms and we're like, that sounds terrible. But what if it works? Like what if it does the things that we say it does? And the two major things that we say bail does is, again, it's for public safety, it's for community safety. The other thing we say is that it helps people come back to court, right? They have skin in the game, they have something on the line that makes them return to court. And what studies have found again and again and again and again for, I mean, literally decades, like a half a century, is that bail doesn't do those things. It certainly doesn't do them any better than just straight up pretrial release does. In places like Washington, D.C., where cash bail is rarely used, people come back to court at rates higher than in places where cash bail is used. And they reoffend at lower rates than places where cash bail is used. And that's true anywhere you look. New Jersey has drastically reduced their use of cash bail. There have been higher reappearance rates and lower reoffense rates than there were before they reduced their cash bail use. So we see time and again as changes are made, as particularly cash bail is reduced, but generally as pretrial detention goes down, the community stays equally safe, people are coming back to their court dates, and the people who otherwise would be in jail, less harm comes to them and their families and communities. So it's a lot of depressing stuff, but I wanted to end on this note. That change is truly coming. MNJRC is working really hard on this, and as I said, over the next 18 months, we'll be doing a study of bail and pretrial detention across the state. And we're really hoping to, again, as Justin said, reimagine how this could look. And the community plays a huge part in that. So I encourage you to stay connected to MNJRC, to really participate in the walk tonight and put your thoughts down on paper, because it will absolutely inform the work that we do going forward. And I'm going to hand it over to Josh Page, who is a professor from the University of Minnesota, to talk a little bit about his research into bail bond companies.
So please do, if you have trouble hearing me, do let me know. Again, I'm Josh Page. I'm a professor of sociology and law at the University of Minnesota. I'm also on the board, research steering committee board of the MNJRC. I think that's what it's called. And you're gonna have trouble following me. I have a couple of students from my class that are here, and I was gonna say, I thought of them because they know how I pace the whole time I talk, so I hope you can follow me with the recorder. It's really an honor to be here. So several years ago, I took a job as a bail bond agent to study the pretrial process in the bail bond industry from the inside. When I began the gig, I had a basic idea of how bail worked. I knew that many defendants couldn't afford bail and that pretrial detention had some of the consequences that Anna described. What I didn't know, however, was there is a huge population of people involved in the bail process who have never been charged with a crime or even accused of one. I'm talking about the friends and family members who pay bail and co-sign the bail bond contracts. When I started working bail, I saw that the vast majority of defendants were men, while the vast majority of people who paid the premiums and co-signed the bonds were women, primarily low-income women of color. So I want to break down these terms for those who aren't as familiar with the bail bond system. The premium is the amount that people have to pay the bail bond company. Typically, it's 10% of the bail. So if the bail is $10,000, the premium is $1,000. The premium, people do not get back the premium, even if the charges are dismissed or the person is found not guilty. Often, people can't afford the whole premium up front, so they take on debt in the form of a payment plan to the bail bond company. Over a period of months, if not longer, they pay the premium in installments. If they don't pay up, the bail bond company threatens to take them to court, garnish their wages, and so forth. Okay, so for nearly every bond, bail companies also require a cosigner. They would describe it as like a cosigner for a loan. Okay, so the cosigner, often the same person who pays the premium, must agree to a contract, which requires them to hand over personal information, such as their social security number. It also gives the bail bond company the right to access private records and search their home if the defendant doesn't show up for court. And the contract puts them on the hook for possible financial charges down the road. I'm going to read a little from Alexis Bail Bonds Cosigner Agreement. It's a random contract I found online, but it's standard language in these contracts. It reads, so this is what the cosigner would have to sign. I understand that I am responsible for the defendant until the case is completely resolved. That means the case has been dismissed or the defendant has been found guilty or not guilty. If something happens and I decide, oh, I messed up my pages. Here, start again. I understand that I have signed legally binding documents. It is my responsibility to let Alexis Bail Bonds know immediately if I change my address, phone number, or place of employment. It is my responsibility to ensure that the defendant is in court every time she or he is scheduled to be there. If the defendant misses any court appearance for any reason, Alexis Bail Bonds can demand immediate payment from me for the full amount of the bond, the $10,000, plus court costs, plus attorney's fees, plus any costs to return the defendant to jail. That means paying for the bounty hunter. Alexis Bail Bonds can sue me to collect this if I do not pay it immediately. Alexis Bail Bonds will add additional fees to the amount I owe to pay for filing fees to sue me. I understand that I am responsible for the defendant until the case is completely resolved. If something happens and I decide I do not want to be responsible for the defendant's bond, I can request that Alexis Bail Bonds file the proper paperwork with the court for a fee, but I understand that my obligation does not end until the defendant is in jail or the case is dismissed. So serving as a cosigner is, as the kids say, a BFD. Nonetheless, people take on these responsibilities in order to get their loved ones out of jail. And I should also note that many people who sign these contracts may not be fully aware of the obligations and financial risks because they sign the contracts in a hurry and often in a very stressful situation, right? They just want to get it done, get the person out. So after going through the cosigner process, people are often grateful to the bail bond company, which isn't all that surprising considering that in our current system, the company provides the only way of getting their loved one out of jail. Still, as the MNJRC study shows, serving as a cosigner can have serious negative consequences. Research shows that many cosigners, the vast majority of whom have limited resources, must choose between paying for bail premiums or necessities, like rent, food, or medicine. For those with slightly more resources, the premium payments can derail the family's financial future from taking from retirement funds and causing some families to mortgage their homes. Bail debt also causes stress for many families. The costs can accumulate to form a debt trap. Some families even take out payday loans at high interest rates to pay their bail contracts. So of course the people who pay bail are also part of communities, typically low-income, racially segregated communities. As research has begun to show, the cash bail system effectively drains wealth from these places, contributing to the racial wealth gap. The amount of money that flows from these communities to bail companies and the corporate sureties that underwrite their bonds is unknown. Unlike government agencies, bail bond companies are allowed to keep their finances secret. However, available data confirm what we would expect given the social and spatial concentration of arrests. In 2016, for example, The Maryland Office of the Public Defender reported that bail companies, quote, extract tens of millions of dollars from Maryland's poorest zip codes, contributing to the perpetuation of poverty. The money bail system has a disproportionate impact on racial minorities. Over 5 years, black defendants were charged premiums of at least $180 million, while defendants of all other races combined were charged $75 million. In a 2017 study of New Orleans, the Vera Institute of Justice found the burden of paying bail, quote, the burden of paying bail, fines, and fees is borne primarily by black residents, most of whom are struggling economically. Black residents of New Orleans paid $5.4 million, or 84% of the $6.4 million in bond premiums and associated government fees in 2015. Well, as I expected, some faces started to glaze over once I started tossing out these figures. While important, statistics don't capture the human side of the story. What it's like to pay bail and experience its various consequences. That's one of the reasons the MNJRC study is so important. It tells the story of cash bail from the perspective of those who pay the premiums and co-sign the contracts. So with that, I will now hand it over to Bree, who has a story to tell her own, but I understand Bree unfortunately couldn't make it, but has a video for us. So thank you again for being here tonight. I look forward to talking to you.
Good evening. My name is Brieanna Waters, and I'm a PhD candidate at the University of Minnesota in the Department of Sociology. I was also a research assistant for MNJRC, working on the bail project. Like some of the other speakers tonight, my own understanding of bail has been shaped through recent research on bail and the findings of the MNJRC bail project. But tonight, I'm going to talk to you about how my personal experience with bail has also shaped my perception. In the winter of 2020, I was assaulted by my ex-boyfriend, and he was arrested and booked in jail. I was physically hurt. I had bruises on my back and arms and a cigarette burn on my chest. But I was also in an extremely vulnerable state, both mentally and emotionally. Before that, I had always kind of seen myself as a strong person who is determined and very assertive, someone who would definitely abandon something that was toxic in my life. In other words, I might have been the person who said things like, I would never put up with that, or why doesn't she just leave him? But after being assaulted myself by someone who I had cared about and I thought cared about me, I felt uncertain and I felt scared, humiliated, and extremely vulnerable. In hindsight, I imagined that that state of vulnerability is part of why a protective order goes into effect when a domestic assault happens in Minnesota. These orders are referred to as DANCOs, Domestic Abuse No Contact Orders. DANCOs prohibit abusers from contacting victims, no face-to-face contact, no electronic contact, and no indirect contact through a third party. Despite the DANCO having gone into effect, I was the first phone call that my ex made after being booked in jail. And then he called over and over and over again, despite the DANCO. In the jail recordings of these calls, he repeatedly apologizes and begs me to bail him out of jail. I tell him that I'm afraid of him, I don't want to bail him out, and I don't want him to contact me anymore. When I stopped answering his calls and I told the jail that my number was not blocked from his account, he had his family members call me, he had other people in jail calling me, and then he had a bail agent call me and text me. Under DANCOs, the restriction of contact through a third party extends to anyone, including bail agents. In the fragile state that I was in, the intensity and pressure of the calls and text messages were very overwhelming. I felt arrested myself by anxiety and depression. I fell behind on school and work responsibilities. I wasn't eating well or sleeping much. And I had immense shame that prevented me from confiding in people who loved me and may have been able to help me. To get the harassment to stop, I agreed to go with my ex's mother to meet a bail bondsman and co-sign for his bail bond. She had sent a long, late-night text explaining that her credit prevented her from using a bondsman to bail out her son. But she said if I could help, her son promised that he would make the monthly payments to the bail agency after that. And she said she would pay the 10% down payment. I had never bailed anyone out before. I had never met or worked with a bail bondsman, and I had never co-signed a contract for a bail bond. I had never seen one. When we met the bondsman, I was asked if I had a job, if I had a car, or if I had a house. My word was taken at face value. I didn't have to provide proof of my answers, and I was offered very little information in return about the contract that I was signing. I did not know what questions to ask. I signed my name in 2 spots on the contract, and my ex's mom gave the bail bondsman the 10% down payment. We left. The entire process lasted less than 15 minutes. My ex did make the monthly bail payments for 6 months after his release on bail. But during that time, he continued to stalk me, harass me, and violate me. When this continued to the point that I was fearful for my safety, I changed my phone number and I sought a no contact order. He immediately stopped making the monthly bail payments after that. Around the time of his sentencing for the assault, I received a letter in the mail requesting my appearance in conciliation court. I had received a monetary judgment against me for not paying the monthly bail payments after my ex stopped making them. I started making payments on my ex's bail just as he was going to prison for assaulting me. He was eventually charged and convicted with an additional felony for violating the DANCO when he called me from the jail repeatedly. Today, I am financially responsible for the bail payments of the person who assaulted me. Since October of 2021, in fact, I have made $80 payments every month to the bail bond company. I won't have that bail paid off until February of 2024, which is a month after my ex will be released from prison. This was my personal experience with bail, and this isn't an unusual or unique story. In fact, as the findings from the Bail Project show, we heard versions and elements of my experience in many of the stories that other people tell about bail. So I want to thank you for the opportunity to share my story with you tonight. I'm sorry that I couldn't be there. Thank you.
All right, I just want to give everybody a second to just pause, and that's a lot, and it's a lot for Bree to hold her space and share her story in this way, and even if it's through a video, it's unfortunate that she couldn't be here in person, but I think it's really important to, give ourselves and then also give just her story a little breath, I am Marci Exsted. I'm one of the research assistants who worked on this project, and so I'm going to just briefly walk us through an overview of the report. So the report itself is kind of still in progress, so pending. It will be out very, very soon, and I'm very excited for you all to get a chance to read it. But just to start out, I wanted to show our whole research team, because this was not just a couple of us, it certainly was not just myself, but this was our entire research team who worked on it. And I think everybody who worked on it gets their, deserves to get a shout out, because we all put a lot of work in this. And really, this report is important and really aligns with the Minnesota Justice Research Center because we really believe that in understanding how the justice system actually currently operates, we really need to be guided by those closest to the problem. And so we ground our work and our values and engage in deeper thinking with community members about what justice means and looks like while putting data behind creative solutions. And that's part of why we're also having this event the way that we are. We don't want to just talk at you. We want to hear from you as well and have you respond to some of the stories that other folks from our interviews for the report are sharing. And of course, we need to give a shout out to the Minneapolis Foundation for their amazing support for this project, and we're very grateful for all of the work that they have been supportive of, and really just kind of handing us a bunch of, wind to behind our backs and enabling us to do this the way that we felt it needed to be done. So I'm going to play a quick video that exemplifies our report and then also kind of explain some of the points, and then I will continue.
Ever heard the phrase, innocent until proven guilty? It's how we all should be treated if suspected of a crime. But right now, that's not happening. Hennepin County's pretrial process assumes guilt and causes harm to the person accused and their communities. When someone's arrested, a judge sets their cash bail. That's the amount of money they have to pay to get out of jail until a trial. Some people can easily and quickly pay bail to be released pretrial. Others are stuck in jail, even for a day or two, and might lose their job or custody of their kids. The destabilizing impacts of the whole pretrial process, from jail time to finding money to pay bail, spiral outward. Encounters with the pretrial system have undercut a mother's ability to provide housing for her children, prevented a nurse from having reliable transportation to her job, and derailed a defendant on their path to recovery from addiction. Pretrial processes affect a defendant's loved ones, especially mothers, girlfriends, sisters, putting whole families on the hook. The current system does not reflect shared values like justice, fairness, and safety. The good news is, work is already underway to change how Minnesota handles the pretrial experience. But a complex problem needs a complex solution, and we need to hear from you. To be part of the solution, read our upcoming report and join the conversation to reimagine pretrial justice in Minnesota.
And that is on our YouTube also, which is
Ever
really
heard
nice.
the
Okay, so just to give an idea, the purpose of the work was really just to determine whether cash bail itself supports or undermines commonly held community values of justice, fairness, and safety, and ultimately whether or not it really meets those purposes that it's supposed to at least be set out to, that appearance to court and then the public safety aspect. So what we ended up doing is to understand people's experiences with pretrial. Specifically in Hennepin County, we reached out to 8 bail bond companies, none of which we were able to interview with, not surprisingly, many of whom actually outright refused. But we also did get a chance to interview with 14 system actors. That includes folks like prosecutors, public defenders, judges. We even talked to somebody who helps to create something called a pretrial risk assessment, which is part of kind of how bail gets set in the first place. And we also interviewed 44 community members who have direct experience with cash bail. And that's whether it's either been set for them because they're facing charges or they've paid for someone else to get out, or a lot of people have had both happen, actually. And that's a fairly common experience. And one of the ways that we were able to talk to so many people with direct experience was through connection with community partners, where we actually set up in-person opportunities to interview. So we would set up a window of time at places like a gate, at Damascus Way, etc., and we were able to talk with people and just interview them right there. And we also had partnerships with the Volunteer Lawyers Network, with Minnesota Freedom Fund, and others who also connected us with some folks that they directly serve in order to get us even more people's voices. So I want to just kind of emphasize that these posters across the room go through all 3 sections of our report, and actually all of the quotes are direct pulls from quotes from people we interviewed. And so our report is comprised of, like I said, 3 sections, and it starts with how the pretrial process actually degrades and punishes folks who experience it, and that's even, like has already been said, before a actual court trial has happened and any kind of decision has been made about their case, whether or not it's even dismissed, right? And then the second portion is how the pretrial system puts communities and families on the hook. And that's financially, but it's also emotionally. We talk a lot about how this process itself feels like a panic, you know, it just feels like a spiral. And it doesn't let you go. And oftentimes, just as Bree kind of talked about, where even if that relationship isn't something positive, you didn't bail somebody out because you wanted them to continue to be in your life necessarily. And so it can keep people on the hook for a very long time. And then the last portion is that the claim that cash bail is a necessary incentive. We really investigate that, especially as relates to court appearance specifically, because a lot of the folks that we talked to, there was kind of evidence showing that a lot of folks would have either just gone to court anyway or didn't really feel like a factor. Cash bail and paying it was really just about getting the person that they loved out or getting, you know, back to their work or their kids or whatever else. So, like I said, this event is about hearing from you all, and I think it's important to note that while we're trying to reimagine cash bail in Minnesota and locally here, this isn't the only place that is doing that. And Anna already talked about a couple places, but just to give an overview, we do see in places as close as Ramsey County is quite literally shifting from a wealth-based system to one that surrounds pretrial success as kind of its aim, which means thinking more so about how can we make sure people are successful in getting to court, make sure people are successful in staying safe in their communities, and how does that work, whether it's through like reducing the amount of cash bail or using alternatives or whatever else. But then also we see in places like Philadelphia that there were no increases in pretrial crime after a no cash bail policy was enacted. In places like New York, people released under bail reform were less likely to be re-arrested. And then there were 11 other locations that we also looked at from various reports that across the nation had no notable crime patterns after reform. So even if, you know, a reform was enacted, maybe crime just didn't even spike. You know, some places it went a little lower, but it really just had no correlation to like impacting that at all, which I think is pretty significant. So even the places that aren't showing an effect, you know, they're balanced out by the places that are showing at least, you know, a positive lack of rearrest and recommit. So I want to make sure that we take time the rest of this event, and I'll pass you on to Kayla here, who will be guiding the data walk. But first, before you all get up and start the interactive portion, I want to just check in and see whether folks have any questions about the report itself, for myself, or for either of our previous speakers as well.
This might be a question for Anna, but I was wondering if you could comment on, there's a lot of focus on the mom and pop bail bond companies, but they are backed up by like 7 huge insurance companies.
Yes.
That are raking in money, hand over fist, and who are financing a lot of the resistance to bail reform. So I just wondered if you could add anything.
I mean, I think that was a very accurate.
I know, that was so succinct.
So I could just say, so.
I think
So I
that's
think
all not mentioned.
Yeah,
It's so powerful.
So a lot of the, so when people think about bail, probably from shows like Dog the Bounty Hunter or whatever, they think about small bail bond companies as, you know, mom and pop bail bond companies as the bail bond industry. But all bail bond companies have to have a surety. They have to have an insurance company that backs their bonds so they can write bonds well in advance of their reserves. And these insurance companies take a cut out of every bail bond premium. So again, if it's the $10,000 bail, there's $1,000 premium, they'll take a cut of that premium, a percentage. And so they are bringing in money all the time, and they hardly ever pay out on bail. It's sort of complicated, but bail bond forfeitures are way less frequent than the bail bond company, this industry suggests. There's just sort of rare, and often when they are forfeited, the bail bond companies have to use their reserves first. And so it shows, like, you know, the amount of times and money they pay out is very small. And so they make a lot of money, and as Camila was saying, is they're actually the motor force behind the political activity that is fighting bail reform and fights for laws that advance the industry. They, so they're the ones paying. So when you see a lot of this, when you see commercials, it'll be the mom and pop places, but it's actually the bail bond insurance company. So it's actually big business. That the bail bond industry is big business. I mean, there are some companies, such like Goldberg here in town, that make a pretty good living, right? But it's really the insurance company, and the dream of a bail bond company is to be their own insurance company. So it's a really good point to think about the political economy of bail when we're thinking about. Yeah, thank you.
I was wondering if there was like a time period that we define pretrial like detention as, because I don't know what the period between like a bail hearing is, or if there's a delay in the time that they get bailed out. So I mean, you know, people be in it for 6 weeks and then get bailed out, and all those negative impacts still happen.
Yeah, I mean,
You want to talk about it?
so traditionally, I think you can only be held for 48 hours, but sometimes you're booked on a Friday, and that means, surprise, like no court on the weekend, so you're gonna get out like Monday at the earliest, and sometimes it's like 2 a.m. Hope people can pick you up. But if you can't make bail, so in pretrial, that's the, you know, time between, you know, when you're booked in jail and then before you actually have a trial for whatever charges you're facing. And please correct me if I'm forgetting anything or missing something. But if you can't afford bail, you could sit in for a very long time. In our report, we found that the average amount of time people were in jail before a trial actually, or, you know, before bail was even met, was around 9 days just on average. And that was skewed tremendously because some people are spending longer than a month in jail. So it really varies, but yeah, if you can't make bail, the idea of a speedy trial is very elusive. It's a little generous to say speedy, I guess. So yeah, but
yeah, I would just say the only thing I would add is, like, regardless of bail or not bail, whether you're in or out, the entire period of time from when you are charged to when your case is resolved is the pretrial period. Yes. So that is all pretrial. And like I said, we call it pretrial because it's faster and easier. Usually you're pleading, right? It's a plea deal or something like that. And so there's the 48 hours between being arrested and when charges have to be put on you. But once you're charged, you could sit there for, I mean, weeks, months. We see years in some states, and that's all technically the pretrial period.
There's one implication of cash bail, which I've never heard anyone talk about. But a good friend of mine was arrested with a couple of felonies, $10,000 bail. Rather than lose $1,000 right away, people raised the money for the $10,000. And the process went on for over 2 years. And as the process came close to trial, her lawyer advised her that it would be good to get a bond instead and get the $10,000 back, for fear that there was going to be a large fine imposed by the court. And the strategy was, if they gave up the $1,000 now, if a fine were imposed, based on her personal circumstances, they never get it out of her, you know. But if you have that cash bail sitting there, the judges are often influenced that, oh geez, I think the fine should be, let's say about $10,000 in order to have money which is easily collected, and now you've lost $10,000 instead of $1,000. The good news is charges were dropped after all that. But we wound up losing $1,000 because of the fear that that would increase the amount of any fine. Have you heard anything about that, or is that a
Josh?
Yeah, so when I did my research, there was times where people would prefer to use the bail bond company even if they could afford that because of the fear that, because people say you get the money back, right? But it always should be prefaced as you get the money back minus fines and fees. And in the last 10, 15 years, court fees have skyrocketed, so you often get a really big bill. And so what happens is the court will take the money for the fines and fees out of the bail. And so, I mean, the problem is even if you do that, then you're still on the hook for those fines and fees. It can still be taken to collections and so forth. But people, people that have been through the system before would know that, and some would choose to pay the bail bond so they wouldn't lose more through the fines and fees and hope that the attorney could get the court to get rid of that. So it is the case. And I think that a big point should be, a big takeaway point from that should always be when we say, well, you could have just paid the court, always say the court minus fines and fees, right? I'll just stop there.
And I must say, I haven't seen that necessarily, not from the people we spoke with, but we did hear from some people, including some of the system actors, just saying that the court would sometimes do a fee for, $78 is the court filing fee, and sometimes they'd set the bail amount for exactly that. So at least they'd get that fee, that cost back. Yeah, Ash.
I have a quick question. Are there ever bail amounts that are too low for bond companies to even be interested? Like, would a bond company pay 10% of a $500 bail?
No.
Or is it typical that then paying the full amount in cash is someone's only option, so then they don't really have options if you don't have that amount of money in cash all at once?
Yeah, absolutely. I've had somebody tell me that their amount was too low, they were told by a bonding company, and so they are actually, the bond company asked for them to pay more than would be 10%, because it was too low for them to take on otherwise. It wasn't in their interest to take it on. So yeah, there's absolutely that middle ground, and there are even, I've talked to judges who have talked about how they've seen bail be set as quote unquote low as $100, $50, and people still can't make it. So.
That's a great point. I won't add to that, but I do want to emphasize something I didn't about the co-signer thing, is that there are plenty of times where people can get the money for the bail, but they can't get a co-signer. So a lot of people stay in jail not just because of a lack of financial resources, but a lack of social resources, right? Because people who are poor are often in social relations, in networks that are also poor. So people sit in jail all the time that their friends and family can pull together the $1,000, but they don't have anyone that will qualify as a co-signer.
Yeah.
Will your report discuss the fact that if you can't bail out and the coercive practice in the plea bargain, which is the engine of mass incarceration? So people know people are desperate in there, you can't get out. Most of the time people will take pleas, even if they're not guilty, just to end the siege.
Yes, absolutely. Yeah, we touch on the fact that plea deals are very, very pressured, especially in the pretrial space, especially for folks who are anxious about getting out and anxious that, they especially if they have a public defender, it feels like a really big roll of the dice whether or not you have a quality public defender. And then even when you do meet with them, you have 15 minutes to go over your case, maybe, before certain hearings, including your bail hearing. You meet with them and that's it. And then, hopefully they advocate for you well, so.
This isn't really a question, but what really stood out to me in Bree's story is that the bond agency only asked financial questions. They never cared about the type of charge or safety or community safety or risk of harm. Do we know if bond companies discriminate based on charges, do any safety or harm assessments, or is it only about money?
Yeah, not that I know of. And it's hard because none of the bond companies either wanted to talk to us or did talk to us. But just from hearing from folks, we never heard them say, "Oh yeah, I was asked about like my safety in this situation."
Yeah, I'm wondering to follow up on that, because I know of a similar case when I lived in Ohio. What would we say to the general public? Because I think a lot of them would say, well, the problem here is a domestic abuser like that shouldn't get bail at all and should just be locked up until they get trial, especially with the threats afterwards.
I think that's really complex, but I think, the idea, so cash bail is in place supposedly for public safety, which in that situation, it obviously didn't serve that purpose. And so I think that's what part of today is to think about like, okay, what do alternatives look like? How do we think about complexities like that? I don't have necessarily the perfect solution, but I think that's one of the reasons why we wanted to have all of these conversations with the folks we did talk to, as well as bringing it to the community and hearing like what makes sense for the folks who are directly experiencing this and having it impact their lives.
Thinking of the play with other like conditions of release, and so we had someone who was in Washington County Jail, and the judge said that they needed to go to treatment, mental health treatment, but in order to go to treatment, you have to usually have a diagnostic assessment. So they said they weren't likely to go get the diagnostic assessment if they were released. So they need to get the diagnostic assessment while in jail. Well, no one in Washington County will go into the jail and give someone a diagnostic assessment. So I don't know how those kinds of things, like if you bail out but you can't meet another condition of release, you just sit in jail?
Yes. Yeah, I think this is a good time to, speaking of, and I'm sorry, that was more of my last answer was more diplomatic than maybe felt satisfying, but hopefully we can actually actively respond to some of the data that we collected, and so I'll pass it off to Kayla, who will be, leading you all in our